In Perrett versus Wolferstans LLP, Senior Costs Judge Rowley determined the final issue in a Solicitors Act 1974 assessment. Following a line-by-line assessment reducing profit costs to £3,864, the court had to step back and decide if that sum was fair and reasonable under the Solicitor's Non-Contentious Business Remuneration Order 2009. The claimant argued the costs were unreasonable as they vastly exceeded the £900 fixed recoverable costs, contending the solicitors failed to warn of this shortfall. The defendant maintained the contract's 25% damages cap provided sufficient informed consent. The judge held the proper approach was first to assess time and rates, then consider the factors under Article 3 of the Solicitor's Non-Contentious Business Remuneration Order 2009. The court rejected the claimant's core argument, ruling that inter partes fixed costs represent a different scheme and do not set the benchmark for solicitor-client remuneration, endorsing obiter comments in SGI Legal LLP versus Karatis. The 25% cap provided adequate client information, and the item-by-item assessment had already addressed reasonableness. The sum of £3,864 was upheld as fair and reasonable. Quote, "I do not think that the quotations relied upon by the claimant from the Court of Appeal in cases such as Kilby support his argument." The decision of Mr. Justice Simon in Nizami expressly refers to an agreed scheme of recovery, which was easily calculated and was fair as a whole, even if the sums were too high in some cases and too low in others, if calculated purely in respect of the individual case. That scheme plainly related to recoverable costs, and the fairness referred to the swings and roundabouts nature of the scheme as a whole. It cannot be said that this means the remuneration recovered is a fair sum as between the solicitor and client, since that has nothing to do with their contractual terms.
For a detailed summary of this decision, visit tmclegal.co.uk.